Dear Commissioner Reynders, dear Mr. Wojan, dear Professor Ruffert, dear Mr. Dahmer, Mr. Dröge, dear students, guests and friends of Europe, ladies and gentlemen. On behalf of the Humboldt University, I would like to warmly welcome you to our first Humboldt speech on Europe in 2020. And it's a great pleasure for me to greet you all as our guests here in our Senate Hall, and as well the guests who are listening and watching via live stream our special occasion here in this day. As you know, this event was one of the many that had to be cancelled due to the pandemic in January, so we are all the more happy that all of you followed our invitation a second time and gathered here today for this long-awaited continuation of our traditional Humboldt speeches on Europe. Commissioner Reynders, we are delighted to welcome you in our midst today, and we are very honored that you accepted our university's invitation to give a speech on the highly topical subject, protecting and strengthening the rule of law in the European Union. The Humboldt speeches on Europe are among the university's most prominent and popular events. The first keynote was given already over 20 years ago by the former German Foreign Minister Joschka Fischer. Since then, over 45 high-ranking statesmen and women, political leaders, constitutional court judges, or financial experts from all over the continent have presented to us their unique views on the current state of Europe and debated with our students. Today you, Mr. Didier Reynders, join the ranks of those speakers. As the appointed European Commissioner for Justice since 2019, he's at the front lines of upholding the rule of law within Europe. Before Mr. Reynders took on the office of European Commissioner, he served the people of Belgium in several high-level political positions, such as Minister of Finance, Deputy Prime Minister, Minister of Foreign Affairs, and Minister of Defense. Mr. Reynders has held elected office for over 20 years. During this time, he has worked with the European Union on numerous occasions, notably and most importantly during the Belgian presidencies of the European Council in 2001 and 2010. Upholding the rule of law has become a more complex and demanding task than ever. It ranges from defending the traditional value of rule of law within the member states to the new challenges that come with the digital transformation of our European societies. The digital transformation asks for new approaches to protecting the rule of law in a highly volatile digital space. Commissioner Reynders is currently working to improve the citizens' access to the justice system and its services by the means of digitalization in order to make it more efficient and transparent. The agenda of this legislation is to not only protect us European citizens, but also to empower them by broadening and facilitating their personal scope of legal action. His perspective on how we can implement modern technologies while protecting citizens' rights and upholding European standards, most importantly the rule of law, has been forged by many years of experience. But the rule of law is not only challenged by the development of new technologies, it is also challenged in its very core by some member states. In this regard, the European Commission is in a very important, but sometimes fragile position. The Commission is challenged by the European Parliament for not protecting civil rights and an independent judiciary within all member states sufficiently. At the same time, the Commission is bound by its limited competences and the character of the European Union as a supranational community that has been formed by sovereign member states. National governments are still in the driver's seat in many fields and hold strong veto positions. This has an effect not only on decision-making on certain policies, but also on the ability of the European Commission to defend the fundamental values of the community. Commissioner Reynders, I can imagine that this has a great influence on your important work in the Commission. To strengthen the rule of law, be it inside or outside of Europe, also means to strengthen accountability to crimes. Since February 2022, it has become impossible to speak on the topics of law and justice without, in the same breath, decrying the international crimes being committed in Ukraine by the Russian Federation in these very moments. Mr. Reynders, tasked by the Commission to investigate these war crimes in Ukraine, has traveled to Kiev 5 times under the threat of his own life to coordinate the research, documentation and collection of evidence in hundreds of thousands of open cases of war crimes. Aiming to close these cases by holding war criminals accountable will, of course, be a gigantic task in the years to come. It is, however, an important part of a country's healing and reconstruction. And as you, Commissioner, rightly pointed out in your speech at the Ukraine Accountability Conference in July this year, I quote, "It is only with justice that we can help the victims and their families. The link between accountability and justice is unbreakable." Mr. Reynders, it is a great pleasure to have you here today. The Humboldt University has a great interest in strengthening the ties within Europe. The popularity of programs such as Erasmus+ or the European Law School among our students reflects this in a remarkable way. We are very much looking forward to your ideas on the current development of Europe and its rule of law, especially in times like these, when we are acutely reminded of the fragility of our democratic systems. I would also like to thank our sponsors and partners, Stiftung Mercator, Wir sind Europa, and the representation of the European Commission in Germany, and the Stiftung Zukunft Berlin for enabling us to hold this event. Thank you very much for coming, and again, welcome at Humboldt-Universität.
Dear Commissioner Reynders, dear Mr. Wojan, dear Professor Blumenthal, dear Professor Ruffert, dear Mr. Dröge, dear students, guests, and ladies and gentlemen, it is my great pleasure to welcome you to today's Humboldt speech on behalf of Stiftung Mercator. For those of you who are not that familiar with what we do at Stiftung Mercator, we are an independent private foundation that develops projects to improve participation and cohesion in an increasingly diverse society, address the impact of digitization on democracy and society, drives forward climate change mitigation, and Stiftung Mercator wants to strengthen democracy and the rule of law in Europe. So the topic of today's Humboldt speech, protecting and strengthening the rule of law in the European Union, is perfectly in line with what we at Stiftung Mercator aim to achieve through our work. The EU is founded on shared values, such as democracy, fundamental rights, and the rule of law. The cohesion of all member states and the commitment to commonly agreed values are the requirements for the existence of the European Union. But lately, and more often and more frequently, we have been witnessing many of these basic values and principles being intentionally undermined and violated. Some governments are fundamentally questioning the EU's shared values and legal community. They diminish the independence of courts, suppress conflicting opinions, restrict freedom of expression and freedom of press, and tolerate corruption within the justice system. These developments show us clearly that our core values cannot be taken for granted. Rather, they must be defended every day, especially during these times of global unrest. When we look at the current situation in Iran, we see the dramatic consequences, especially for women, when there is no rule of law. For this reason, Stiftung Mercator funds various projects that promote research and analysis on the rule of law in the European Union. We strengthen experts in rule of law from theory and practice, interconnect them through our network, strive for better public communication on this topic, and try to raise awareness of its values all around Europe. One specific example for this approach is the Mercator-funded project Reconstitution. Since 2019, Reconstitution has been promoting exchange between academia and practice about the rule of law and democracy in Europe, and provides timely analysis on rule of law issues in the EU. At the same time, it is particularly important for Stiftung Mercator that young people get involved in Europe, especially when it comes to key values such as democracy and the rule of law, which have been more under attack than ever since the Russian invasion in Ukraine. We want all young Europeans, regardless of their geographic or socioeconomic background, to be able to identify with the values of the European Union and to engage in democratic processes. Therefore, we at Stiftung Mercator are very pleased to support the Humboldt speech within the project We Are Europe. This joint project between Stiftung Zukunft Berlin, Humboldt University Berlin, and the International Journalists Program enables young people, journalists, and civil society actors to discuss their ideas on the future of Europe with European decision makers and actively shape the future of Europe. I would therefore like to thank all our project partners for working towards this goal and for organizing today's event. My special thank, of course, goes to you, to today's speaker, Commissioner Didier Reynders. I'm looking forward to your speech, and I wish everyone an inspiring discussion today. Thank you.
So, dear students, dear President von Blumenthal, and thanks for your introductory remarks. Dear Professor Ruffert, it's true that the Humboldt speeches on Europe are one of the most important fora for discussions on the future of Europe, which makes this the right place to talk about one of the biggest challenges Europe is facing: protecting and strengthening the rule of law. And it is an honor to be here with you today. Originally, I had been scheduled to talk to you in January this year. That would have been a very different speech. What has happened since then, the unprovoked, unjustified Russian military aggression in Ukraine, has been a stark reminder of why, more than ever, it is so important to find, to protect our values. The war of aggression in Ukraine is not just a violation of international rules. It is a deliberate attempt to discard those rules. It is a tragic reminder of the consequence that the absence of the rule of law can have, including for the international community as a whole. As the President of the Commission, Ursula von der Leyen, put in her State of the Union address, I quote, "This is a war on our energy, a war on our economy, a war on our values, and a war on our future. This is about autocracy against democracy." The people of Ukraine are fighting exactly for those values that are at the core of our European identity. These founding values, set out in Article 2 of the Treaty on European Union, are respect for human dignity, freedom, democracy, equality, human rights, and the rule of law. As we work together to help Ukraine defend its sovereignty and integrity, we can only remain credible if we protect the rule of law and our common values also within the European Union. For a long time, we could assume that the rule of law is uncontested and incontestable. As my esteemed compatriot and President of the European Court of Justice, Koen Leenaerts, put it. We could believe that this has become part of our raison d'être or our DNA. Yet, more recently, we have experienced developments where the rule of law is openly challenged. Russia itself shows us that what happens where there are no more checks and balances in place. If there is no free and pluralistic media or civil society to hold an authoritarian regime to account, no independent court to halt unlawful military action, no independent prosecutor to investigate government corruption. And foreign autocrats don't stop at home. They are trying to export their model and undermine our European democracies. For too long, many of us have taken democracy and the rule of law for granted. Today, we see clearly we must fight for our democracies every single day. We must protect them both from the external threats they face, but also from the vices that corrode them from within. The challenges we are facing are not going away. On the contrary, they've become a growing matter of concern for everyone. Let's recall for a moment what is at stake here. The rule of law ensures that everyone is treated equally before the law without political interference. It is about the functioning of the checks and balances of our democratic systems. The rule of law is about the fight against corruption and the protection of taxpayers' money against misuse. It allows a plurality of media to operate freely as a source of information and democratic discourse. And the rule of law protects and enables civil society to operate freely and safely as a watchdog on political powers. To be clear, the rule of law is of existential importance for the European Union. Without it, the European Union, which is a community of law, will no longer be able to exist as we know it. The rule of law guarantees the effective application of Union law. Its effective application is not only entrusted to the European Court of Justice, but in most cases to the national courts of the 27 member states. An Italian or a Polish judge, for example, is a European judge. If a judge is not independent, how can we trust that EU law will be effectively applied? Furthermore, the rule of law is essential to ensure mutual trust in Europe. Mutual trust is the very foundation of cross-border judicial cooperation in the Union in both civil and criminal law. This is an issue that ordinary national courts are now facing in their everyday work, whether they are dealing with the execution of a European arrest warrant or a cross-border child custody case. And this is the moment when also citizens in their daily lives could suddenly be confronted concretely and directly with rule of law issues. Mutual trust is also the basis for other forms of cooperation across borders. For example, in city partnerships, on everything from sports to cultural matters and binational schools. This is when our municipalities and cities might find themselves suddenly faced with very difficult questions. Can I continue my town twinning partnership when the partner side from another member state has decided to declare itself an LGBTIQ-free town? Without the rule of law, we also risk the functioning of our internal market and the prosperity it is creating. We need to be able to trust that European courts guarantee our rights everywhere in the internal market. Otherwise, investors, creditors, companies and consumers will be less inclined to be active across borders. Market barriers and transaction costs will increase. In short, the rule of law is not negotiable. It is not a question of finding a political compromise somewhere in the middle. The rule of law is something we need to defend. I strongly believe that this is a joint responsibility of all of us, politicians, academics, legal professionals, civil society actors, students, and teachers alike. How can we protect and strengthen the rule of law in Europe? How do we stand up for it? This is what I want to speak to you about today. Let me start with the dialogue on the rule of law. When I look back over recent years, it is clear that at EU level, there has been a change in the approach to dialogue on the rule of law. A decade ago, when I was Belgium's Minister of Foreign Affairs, I wanted EU ministers to have an honest discussion about the situation in Hungary. And again, in 2016, I proposed in the Council a discussion on the rule of law between the ministers in a peer review format. But back then, there was no real interest or willingness from my ministerial peers to have such an open discussion, except with a small group of friends of the rule of law, and I must confess, including my German colleague. Today, the rule of law, including discussions on individual member states, has a permanent place on the agenda of the Council of Ministers. How did this change come about? An important moment came in July 2019. President Ursula von der Leyen again made a commitment that the Commission will henceforth come forward with an annual rule of law report that covers all 27 member states on equal footing. This was a key element of our political guidelines for this Commission, and the President tasked me to lead the Commission's work on this report. Under my responsibility, the Commission has published 3 of these annual rule of law reports so far. The most recent edition was adopted in July this year. The findings of the reports are based on written input from national authorities, NGOs, media outlets, judicial representatives, and many others. Commission services also had several hundreds of meetings with these authorities and stakeholders. The report's findings are objective and there for all to see. They are discussed amongst Member States ministers in the Council, in the European Parliament, with national parliaments, with NGOs, professional stakeholders, and in academic conferences. In the General Affairs Council, ministers discuss every 6 months, under every Council presidency, the rule of law situation in 5 different member states. The next discussion will take place in December and cover Poland, Portugal, Romania, Slovenia, and Sweden. In spring next year, the Council will have discussed the situation in each of the 27 member states, completing the first cycle of country-specific dialogue. And we are following the protocolar alphabetical order to do that, to don't have any discrimination in the process. Moreover, once a year, the ministers hold a discussion on the general rule of law situation in the EU just after the publication of the annual report. In parallel, justice ministers have also taken up the good practice of discussing twice per year justice-related rule of law issues in the Justice Council. And I'm hoping that it will be possible to do the same in other formations of the Council. I have had some discussions with ministers in charge of education. Why not to discuss in such a council about the place of the rule of law in the educational process? It's maybe one of the tasks for the next years. Without the report, as a factual and objective basis, I do not think there would have been much willingness to have such discussions. Being in Berlin today, it is only fair to recall that Germany has played an important role in making this possible. It was the German Council presidency in 2020 that launched these discussions for the first time about 5 member states. But this debate needs to become broader still. I'm determined to take it to national capitals and parliaments and to involve more closely civil society. For example, tomorrow I will discuss with committee members in the Bundestag and in the Bundesrat. This year, we are also taking an initiative to facilitate the involvement of civil society at national level in the follow-up to the report. And this year's report takes another important next step. For the first time, it includes specific recommendations for each member state. These recommendations are preventive in spirit. They aim to support member states in their efforts to take forward reforms and point out areas where improvements or follow-up are needed, including sometimes for serious concerns. I know that the rule of law report is quite long, with 27 different chapters for the different member states, but there is an abstract of 1 page for each member state, and there is 1 page with the recommendations. So about Germany, it's just needed to read 2 pages. And if you want to read all, it's just more than 50. So it's not so much. But if you have the opportunity to read the whole report, it will be, of course, better. And all member states have areas where they can improve and learn from each other. And the recommendations show this. This is also true of Germany. Let me just give 2 examples of what we have recommended to Germany. To provide adequate resources for the justice system, including when it comes to the level of salaries for judges. Adequate resources are crucial for an efficient, high-quality and independent judiciary. And to introduce a so-called legislative footprint. This would allow for the monitoring and tracing of all interest representatives who seek to influence and contribute to specific legislative texts. The Commission stands ready to support Member States in implementing these recommendations. We will continue our dialogue at political and technical level on this basis. Academia, I strongly believe, also has an essential role to play in the dialogue on the rule of law. Wilhelm von Humboldt envisioned a university as a place to exchange ideas, where research and teaching can come together. And Walter Hallstein, a lawyer, academic, and founding father of the European Union, envisaged a Europe with the rule of law as its foundation. This is still providing inspiration today, not only for your institute bearing his name. During the pandemic, the College of Commissioners has been meeting in the room in the Commission's Berlaymont building bearing his name, because we need more places during the pandemic to organize the meeting. I want us to uphold the visions of Wilhelm von Humboldt and Walter Hallstein today. I want to share my ideas and maybe later hear yours. The Commission's approach to dialogue is based on prevention, on detecting rule of law challenges as early as possible, and, of course, addressing them. And here comes another point that is important to me. All member states, also those performing overall well, can still improve and learn from each other. Moreover, we can see that our report is having an impact on the ground. Between its first and third edition, we have seen quite some positive justice reforms. A number of them have been influenced by the findings of the reports and the exchanges that followed with the Commission at political and technical level. For example, in Luxembourg, After dialogue on the basis of the report, amendments have been tabled to align the composition of the future Council for the Judiciary with European standards. In other member states, concerns flagged in the report have been taken up in the context of the national recovery and resilience plans. For example, in Italy, where a number of important reforms are ongoing to address long-standing efficiency challenges in the justice system. I'm glad to conclude that in Europe, dialogue on the rule of law is overall getting stronger, not weaker, and that it is producing results. I noticed that international interlocutors start asking us to share our experience with them. We should build on this in the future, also for our external relations. Ladies and gentlemen, as the President of the Commission has recalled, dialogue always comes first. But dialogue is not an end in itself. It should lead to results. Unfortunately, we do not always see such results. We therefore need a dual approach of dialogue and decisive action. In fact, the Commission has significantly strengthened the toolbox of reactive instruments at its disposal and the usage it makes of them. Let me be clear. The objective cannot be to impose a particular model for national justice systems in the member states. But we do need to make sure that the fundamental principles of the rule of law are respected everywhere. Among our enforcement instruments, I would in the first place mention infringement proceedings. Let me recall that it is now more than 4 years since the European Court of Justice issued in 2018 its Portuguese judges' ruling. In this landmark judgment, the Court confirmed that from the requirement of effective judicial protection anchored in Article 19 of the EU Treaty, member states are under a general obligation to guarantee the independence of their national courts. In line with this requirement of EU primary law, the Commission has initiated key infringements when national legislation violates requirements of judicial independence. The case of Poland illustrates this. Among others, in 2019, the Commission brought the Polish disciplinary regime for judges before the European Court of Justice. In that case, the Court already issued a ruling on 15 July 2021. It entirely upheld the Commission's action, requiring Poland to change its disciplinary regime for judges. Meanwhile, Poland has made commitments under its Recovery and Resilience Plan that, if fully transposed and applied in conformity with EU law, could ensure compliance with the judgment of the Court of Justice of 15 July 2021. Moreover, in 2021, the Commission referred Poland to the Court of Justice over its recent law on the reform of the judiciary to protect the independence of Polish judges. That action is still ongoing. The European Court of Justice held a hearing in that case in June. I'm aware that it takes time to prepare such legal actions and to obtain a ruling. Therefore, this Commission has also requested interim measures in the 2 cases I just mentioned. We needed to avoid serious and irreparable harm to judicial independence and the EU legal order. In both cases, the European Court of Justice followed the request of the Commission with its interim orders of 8 April 2020 and 14 July 2021. Our enforcement does not stop here. When Poland did not fully implement the court's interim order of 14 July 2021 concerning the Polish law of the judiciary, the court ordered, after a request from the Commission, a penalty payment of €1 million per day. As of today, Poland has still not fully implemented the interim order of the Court of Justice delivered in July 2021. While the Commission welcomes that a number of judges suspended in office by the disciplinary chamber have been reinstated in office, not all relevant decisions of the disciplinary chamber have seen their effects suspended. Also, some of the contested provisions of the national legislation that Poland is obliged to suspend continue to apply. The Commission will continue to ask Poland to pay the daily penalties imposed by the order of 27 of October 2021 until all interim measures have been satisfactorily addressed or until the order is cancelled or varied by the European Court of Justice. Till now, we have asked Poland to pay €332 million. With the refusal to pay, we have organized a setting-off on the payment due by the Commission to Poland for €267 million, and we will continue to organize such a process. Let me assure you, the Commission is not doing this lightly, happily, or proudly. We would very much prefer not to be forced to act in this way. Ladies and gentlemen, it is normal to have differences and political discussions between the Commission and a member state. But once there is a final ruling of the European Court of Justice, the matter is settled in a binding manner for both sides. This is why the ruling of the Polish Constitutional Tribunal of the 7th October 2021 is also of serious concern for the Commission. The Polish Constitutional Tribunal ruled at the request of the Polish Prime Minister that parts of the EU treaties are unconstitutional. This has never happened before. The ruling expressly challenges the primacy of EU law and rejects the interpretation which the Court of Justice gives to Article 19 of the treaty and the requirement of judicial independence. Therefore, the Commission decided on 22 of December 2021 to initiate an infringement procedure against Poland as regards the ruling of the Polish Constitutional Tribunal. Next to a violation of primacy of EU law, the Commission has serious doubts that the Constitutional Tribunal still meets the requirements of an independent and impartial tribunal established by law. This case is ongoing. On 15 July 2022, the Commission took the next step in the procedure and addressed a reasoned opinion to Poland. We are currently analyzing the Polish reply. And since we are in Germany today, let me add one side remark. The case law of such a prestigious court as the Bundesverfassungsgericht is closely observed throughout Europe. If the Bundesverfassungsgericht defies a judgment of the European Court of Justice, certain other constitutional courts in Europe may invoke it for their very own purposes. We have seen this happen, and is the reason why we have also to react where we are looking to a specific problem in all the different member states, including in Germany. The Commission's enforcement in rule of law matters is also being strengthened by new instruments, and not only all those infringement proceedings before the Court of Justice. One is the conditionality regulation, which was adopted in December 2020 and applies since the beginning of 2021. It makes a link between respect for the rule of law and the protection of EU funds. It responds to long-standing demands, for instance, from the European Parliament and many citizens. They widely fail to understand how it can be that the EU budget is not protected against breaches of the rule of law. In February, the Court of Justice confirmed the validity of this instrument, and we are applying it. Currently, one case is ongoing regarding Hungary. In that case, on 18 September, the Commission proposed to the Council to adopt measures to protect the EU budget. This step builds on an intensive dialogue between the Commission and the Hungarian authorities over the past months. This resulted in Hungary proposing a wider range of remedial measures to address the concerns identified by the Commission. The Hungarian authorities now need to take a number of key implementing steps. Pending that, the Commission considers that the risk for the EU budget remains. Following an extension of the deadline, the Council now has until 19 of December to decide on this matter. Hungary is committed to fully inform the Commission about the implementation of the remedial measures by 19 November. We will carefully monitor the implementation of all these measures in order to assess whether the EU budget is effectively protected from the identified risks. There would be more to say on other instruments, but it already illustrates that the Commission has the instruments at its disposal to take decisive action where it is necessary. It can bring matters not only before the Court of Justice, but also before the Council of Ministers. Our increasingly stronger enforcement toolbox will allow for a strategic approach to react to rule of law challenges. And I want to say that, of course, it's very impressive for many governments to read the recommendations in the rule of law report. But as you said, I was also in charge of the finance department in my country, and I know that maybe the possibility to have a suspension of funding coming from the European Union is also very impressive. And when I'm speaking about different instruments, it's true that sometimes we have combined the recommendations in the country-specific process in the European semester with the recovery and resilience plan to say it's possible to pay some funds in the recovery and resilience plan coming from the next generation EU budget if we have the certainty that there are some reforms also dedicated to the justice system. So the combination of different instruments is also possible. And of course, again, the financial pressure is at least also very important, like the rule of law report or the infringement proceedings before the court. And ladies and gentlemen, this leads me to another important task, and maybe the most difficult one, if we want to strengthen the rule of law: the creation of a rule of law culture across Europe. Are we, as citizens, as Europeans, sufficiently aware of the situation of the rule of law? Are we sufficiently discussing it, not only in our institutions, but also in our associations or homes? Some may ask why the problems of a far-away judge should matter for them. Don't we all have our own problems to solve? So here are some questions that we could all ask ourselves. What does the rule of law mean for our daily lives? If you consider your rights denied by the authorities, can you go to court and trust that the judge handling your case will be independent and impartial? If you are a business owner competing for a government contract, can you be confident to be treated fairly and not to lose out to a competitor simply because the competitor is close to the governing party? Can journalists operate freely and without the threat of abusive lawsuits looming over them? Some months ago, I had an impressive discussion on this with students of the arts in Budapest. Their university had been privatized to a government-controlled public interest trust. They managed to create public awareness and support for their concern about academic freedom. Ultimately, they left the university and continued their academic work in the form of an association. Ladies and gentlemen, building a rule of law culture, an awareness and understanding of why the rule of law matters for our daily lives is a joint responsibility. It cannot be a task for Brussels alone. I'm therefore glad to see that national governments and parliaments are holding debates on the rule of law and promoting knowledge and information among the general public. Germany, for example, has successfully carried out a public awareness campaign as part of the Pact of the Rule of Law. We need to see more efforts like this. Another natural partner is this task is civil society, because the task to promote the culture of the rule of law is a task for the entire society. And with civil society organizations, we have an essential partner in our constitutional democratic society. They bring life of EU values and rights. As a watchdog, they spot early on the warning signs for threats to the rule of law and keep institutions accountable. For the Commission, it is important to foster and protect an enabling environment for civil society actors. To protect civic space, the Commission launched infringement proceedings against Hungary over a law on foreign funding for civil society and a law criminalizing aid to asylum seekers. The judgments of the European Court of Justice in those two cases have set a precedent against such legislation. The Commission is also taking action to promote civic space. This year, civic space will be the topic of the Commission's annual report on the application of the Charter of Fundamental Rights. The report will be published in December and provide a basis for discussions with member states on the civic space. Moreover, civil society organizations are already providing the Commission with valuable input on the rule of law situation on the ground. Their input is an important and well-recognized source for the preparation of our rule of law report. As I already mentioned, we want to intensify the involvement of civil society in the follow-up to the rule of law report. The discussion were having on its basis. Together with the EU Fundamental Rights Agency, the Commission, via its representations in the Member States, is offering a new format to facilitate this. This initiative has started this week. On Tuesday, I participated in the first roundtable in Belgium with Belgian civil society organizations and stakeholders. Today and tomorrow, such a civil society dialogue on the rule of law is taking place in Berlin. And we plan to launch more such dialogues across Europe. They provide valuable opportunities for us to listen to civil society's views, to bring different stakeholders and authorities together, and to see how they can best work together to follow up to the report, especially the recommendations. Ladies and gentlemen, education and research is another area which is important to strengthen the rule of law culture. Being here among you, academics and lawyers, I know that this may sound like preaching to the convert, but let me say it nevertheless. Universities are key actors to promote the rule of law, human rights, and international norms and standards. They are key to promote active citizenship, tolerance, equality, diversity, and critical thinking, to increase social cohesion and social trust, and thus to protect European democracies. And of course, universities have an active role to play to prepare graduates to be well-informed European citizens by teaching and awareness-raising actions. They contribute to anchoring European values in society. And by upholding scientific rigor, they help to strengthen trust in science. As law students, you have a special role and responsibility. You represent the judges, prosecutors, lawyers, and government officials of tomorrow. Some of you might also become ministers, prime ministers, and presidents. And even at the highest level, there is room to learn from one another. Earlier this month, in Brussels, the Commission held the first conference of constitutional courts of the European Union. My invitation brought together presidents and other senior judges of member states' constitutional jurisdictions, as well as the presidents of the European Court of Justice and of the European Court of Human Rights. Together, they discuss how constitutional jurisdictions can contribute to the protection of the rule of law in the European Union. I want to say that this conference was a fantastic opportunity to exchange and to strengthen dialogue between the European Court of Justice and the constitutional courts in the member states. And so, in such a way, we'll organize the same conference every year. It will become to be a tradition, and it's very important to exchange in all the different possible fora about the rule of law. And for the discussions between the court, let me therefore close by quoting again the president of the European Court of Justice, Koen Leenaerts. It is ultimately a society's commitment to the rule of law, democracy, and fundamental rights that gives force to that document and thus to judicial decisions. Without respect for those values, a constitution or a treaty is no more than a piece of paper. Therefore, individuals must be convinced and must constantly be reminded that in order for them to enjoy liberty and justice, judicial decisions must be respected. End of quote. This act of convincing and reminding each other of the importance of the rule of law is a responsibility for all of us. And I count on everybody, the EU institutions, the governments of the member states, the judiciary, lawmakers, and all of you here today, and everyone living in Europe, to do their part as well. It is nothing less than the future of our union, which is at stake. Thank you very much.
So thank you very much, Commissioner Reynders, for this. Merci. Thank you. Thank you so much for your speech that inspired us. And it's not frequent that those who do the Humboldt speeches are also trained lawyers. I mean, many presidents, prime ministers, you will now listen to the future judges, prime ministers, and presidents, but there are many professions they have, so it is also an interesting discussion for perhaps the majority. I wouldn't dare to say this, but it can be that of the students may be law students. So this may inspire their questions. Now, the floor is open, as I said, with a preference to our Humboldt University students. Please, your questions are very welcome. Do as you do in the lectures. We often have a great commitment here. So, who wants to be the icebreaker? Have this function.
We may start with the second question, if it's...
Okay, Herr Gasperin, please, yes.
Thank you so much. I'm a PhD student at Humboldt University. Let me first salute you for the work in the last few years that you've been doing. And now my question, which is kind of straightforward, a bit provocative perhaps, but what is the rule of law? Is there only one meaning of it? And if it is it a political one or is it like judicial one? And if it's a legal one, is there a Court of Justice of European Union which has the monopoly to define it? And if not, if other courts should play a role in defining it, how then we should overcome those obvious differences that we are facing? Yeah, thank you.
Well, I've given elements of definition in my lecture, but I want to add that we have enshrined in the treaty some values, and certainly in the Article 2 of the treaty. But exactly like we have seen the same kind of organization at the national level in the different constitutions. We have put also in many national constitutions a set of values. And what we try to do is to say that also if you have, after the elections, a majority to form a government, sometimes, it's not the case for the moment in Germany, but sometimes with only one party having the majority, it's not because we have such a position that it's possible to pass all the possible laws. Also the laws must be aligned with the value enshrined in the Constitution or in the Treaty for the European Union. And that's the important element, because sometimes, and I have the feeling that's maybe also the sense of your question, sometimes there are people opposing democracy and the rule of law. It's not true. Democracy, of course, is the possibility to have fair and free elections and to have, at the end, a majority to govern the country and to go maybe to the parliament to pass different laws. But also when you have such a majority, you need to have a full respect in the different laws that you try to pass in the parliament for the values enshrined in the treaty. And who is in charge to verify that is true is the judicial system. It's the reason why in the rule of law report we start in the first chapter by the justice system to be sure, like is also in the treaty, Article 19, that we'll have an independent justice system. We don't ask to the member state to have the same justice system. We ask just to have an independent one and to be sure that, like it's also in the Charter of Fundamental Rights, to be sure that the citizens, all individuals, but also the businesses, will have an access to an independent and an impartial judge. And of course, at the end, because it's also the question, you will have a final decision in justice. In Europe, if it's in line with the EU law, it will be the European Court of Justice. Like you have a constitutional court or you have Supreme Court in different member states for the national legislation. And I don't want to quote exactly, but it was a sentence of a judge of the Supreme Court in the US. Why is it so important to have a full respect for the decisions of such a court? Because the Court of Justice in Europe is the only one having the possibility to give an interpretation to the EU law and the decision are binding. But such a court, like the Supreme Court in the US or like a Supreme Court in many other parts of Europe or of the world, is not of last resort because the court is incontestable. No, the court is incontestable because the court is of last resort. You need to have somewhere someone to say the last word. And after the entire procedure, it's normal, it's true, that the final decision is in the hands of some judges to give an interpretation to the EU law with the Court of Justice or It was the same before the national level for the highest courts. And it's the reason why also it's so important to protect the independence, impartiality, quality, and efficiency of the court, because it's the last guarantee for the protection of all the fundamental rights. And so that's the rule of law, the reality to have a real necessity to have full respect for some value enshrined in the Constitution, the treaties, and an access to justice to ask a full compliance with that from the authorities like from the citizens.
Thank you so much. Are there further questions in the room? Yes, lady, just in front of me.
Hi, thank you so much for your speech. I'm currently an intern in the Ministry of Justice, and I was wondering about the cooperation between the Commission and the Member States on reaching this goal of protecting the rule of law. What do you think are the divided tasks? What should the Commission's task be? Who should be the driving force? What should the Member States do, apart from implement the recommendations, obviously? Thank you.
Oh, it's a real cooperation that we have, of course. And I will say from the beginning, we start in 2020 with the first report. We have discussed with people from all the member states about the methodology, because it's the first element, of course. You know, if we want to publish a report, you need to agree, if it's possible, on the methodology and the way to collect different informations from different sources. But we are working during the whole process with the member states. And I said also with many other stakeholders, also from the civil society, but with the member states to exchange, to collect information, and at the end to give a chance to the member states to propose some changes in the factual elements that we are putting in the report, because it's a normal debate, not on the recommendation. We don't give, you know that, the recommendation to the member states before the adoption by the Commission, because it's the assessment of the Commission. But what is possible to do, it's to continue a dialogue on all the recommendations and more in general on all the different problems that we have seen, or that it's possible to see that they emerge in one member state. And if it's enough, we are doing that, and we try to improve the situation in all the member states just with a dialogue and the possibility to make progress. If it's not, if the dialogue is not enough, or if we are considering that one reform, if one member state is against the EU law or against the values that we have enshrined in the treaty, but it's the same, it's also the EU law, we need to use other instruments. And I will say there are two categories of action in that. With many member states, and with all, we are going to the Court of Justice with infringement proceedings. But if it's more systemic, like maybe for the moment in Hungary and in Poland, we try to use other instruments like the Article 7 and the procedure that we have before the Council. The conditionality mechanism that I've mentioned is also another instrument. But in fact, it's a dialogue with the member state, and the goal at the end is to work just with that. If it's possible to use just the report and the exchange with the member state to improve the situation, it will be the final result of our work with the rule of law report. But again, I said, sometimes we need decisive action. So be sure that we'll continue to exchange and to dialogue with the member states and with the different departments in the member state. But if the result is not satisfactory, we have to use other instruments.
Thank you so much. I saw an advanced student raising his hand in this side of the room.
It's very advanced. Commissioner, I was a former head of the representation of the Commission here in Berlin. I'm also a Hungarian citizen. I could ask you many questions about my second country. But I will stop short on Germany, because we are well aware about the deficiencies here regarding the access to courts, the cost, the duration of procedures, the lack of digitalization, also the problem of money laundering control Germany has. My question is how far Germany is progressing on these deficiencies. Are there other infringement procedures in the air? We know about the recent court decision regarding the Vorratsdatenspeicherung, preventive data storage, the refugee matter just a few days ago. And I would like to ask whether citizens can address the Commission regarding such deficiencies here. I know of a case where the state attorney has leaked Article 10. This is a communication secrecy article in the German Constitution to the press, destroyed a whole case, and after the person was cleared, the courts are blocking any further investigation and any further court cases because it concerns Secret Service of the country. So Germany has a problem with Article 10, Vorratsdatenspeicherung and other cases. How is the access of a citizen to European procedures, infringements, to repair and to accelerate what is so slowly going on in the German court system?
First of all, thanks for your first remark, because since sometimes I've seen that in many member states, when I try to discuss about the rule of law, all the participants are speaking only about the two usual suspects and not about the national situation in the country where I try to come. And so it's fine that you said we speak more about Germany than about your second country, Hungary. I'm open to discuss also about that, but it's very important to enhance the capacity to discuss about the rule of law in all the member states. And that's the first reaction about your question, what is possible to do for the citizens? We try to organize more and more debates and follow-up of the rule of law report with the entire society. It's not easy, it's true, but it's not only with my presence during one table, it's also to ask to many civil society organizations to organize debates about the different recommendations and to try to organize a real cycle now that we have the report every year and to try to take all the society on board. But it's, again, it's difficult and we try to make progress on this. The second remark, of course, there are some procedures for the citizens to alert, or the Commission. We receive a lot of alerts and to alert different other institutions, but Germany is also part of the Council of Europe. And you know, I spoke about not only the European Court of Justice, but the European Court of Human Rights, and there is a direct access from the citizens after, of course, the procedure at the national level. But more than that, I want to say that you mentioned different problems. I don't want to maybe answer to all, but if you read the recommendation, you will see that about digitalization, there are some efforts in Germany like in many other countries, but we have to do more, to continue to invest in the digitalization of justice system. Again, I was myself Minister of Finance, and I know that we have started in many countries in Europe to digitalize the tax administrations, to collect taxes, and you have maybe relations with your tax administration by digital means, more than with the justice system. But it's time to do the same and to invest a lot in the justice system. Due to the COVID, it was more easy to understand the needs, and we have seen that it was possible for many member states to invest. So again, in Germany there are some efforts on this, and we ask to continue and to do more. About the access to information, 2 remarks. We ask also to make progress about a specific law in Germany about the access to information at the federal level for the journalists, and that's very important. I've just had a discussion with journalists, but also people from Transparency International. They ask also transparency when you spoke about money laundering, what kind of register to have a better information about the owner of different assets or different shares in companies, what are the owners of different companies. So if you read the recommendation, you will see some elements on this. And so we'll continue to engage the dialogue with the member states, also with Germany, to make progress. And next year, to be very concrete, in the 4th edition of the report, we'll have to assess the implementation of the recommendation. Is it possible to see real efforts in the digital resource, human resource, financial resource for the justice system? Is it possible to see a better access for the journalists to information at the federal level? And is it possible also to have a better transparency? And because you have just mentioned at the end, intelligence service, you know that we have many discussions on this. Myself, I've had a long negotiation with the US to see how it's possible to transfer personal data from EU to the US with a full respect from the US to the protection of those personal data, so to ask to the security services, intelligence services in the US to have an access only if this is necessary and proportionate, but we have the same discussions in the member states. You are aware about the discussions concerning the use of spyware or special investigations tools like spyware Pegasus in different member states or Predator. And we try to receive more and more information from the member states about what kind of legal frameworks into place to organize the process. And in my view, but that will be a discussion also with the member states, we need to have a legal framework to organize the way to proceed in the intelligence services. And we need, if they want to use special techniques or special investigations, they need to ask the authorization to a judge. And again, we are going back to the independence of the judiciary to give a guarantee to fundamental rights. But it's a difficult issue because, you know, national security, it's a very sensitive issue. It's the reason why I've started to speak about our negotiation with the US, because in the US it's maybe more sensitive than in many other parts of the world. But I know that in Germany, the protection of personal data, the protection of privacy is very high in the concern of the society, of the citizens. And I must say that I've seen that in many discussions at European level, because sometimes we try to organize a new process with a new legislation, and when there are some risk for the privacy, it's very sensitive in the discussions with German partners. But again, you will see, we'll continue to ask the correct implementation of the recommendation, and it will be possible to make an assessment, and if it's needed, to launch infringement proceedings. I don't want to be too long, but just to say that you ask, is it possible? Of course, we have launched infringement proceedings also against Germany in different cases, not only about one decision of the Constitutional Court, also about different legislation that follow us. They are in contradiction with the EU law and with the different elements enshrined in the treaties or in the secondary law at the European level.
Thank you. Oh, there are many questions now. Please, Savidi, I think it is, yes.
Thank you. You mentioned the importance of talking about the rule of law, and I completely agree. But when you also see the other side, like you mentioned Poland, where there have been rulings from the Court of Justice which they are not implementing and following, and you said that obviously in the treaties there are Article 7 procedures, etc. But do you worry that maybe these may not enough, that the EU does not have all the means necessary in order to enforce and strengthen the rule of law in some of the member states? Thank you.
Different elements, but I will try to be brief because there are many questions. I've seen many hands. First of all, I said in my remarks, it's quite recent, the real discussion on the rule of law. Maybe because we have saying that it was granted, like I said, and many people were thinking that with the accession in the EU, we had a normal process, and maybe also in Europe with the participation of Russia in the Council of Europe and with the different agreements that we have on the continent, it was possible to see all the countries also out of Europe making progress. And unfortunately, not only with the Russian aggression in Ukraine, there we have seen that it's possible to breach all international rules, but also in the EU. We have seen that we need to pay more attention to the rule of law also after the accession to the EU. And it's the reason why since some years I've mentioned my proposal since 2016, but at the same moment there were discussions in the European Parliament on this. And from the same period of time, I've mentioned a decision of the Court of Justice about the Portuguese judges. It's become to be possible for the two courts in Luxembourg and in Strasbourg to define better what the independence of the judiciary is. And we have more and more case law about that. So first response is quite recent, the real discussion on the rule of law, and I'm very happy that it's a case, but it's recent. Second element, we have now a huge set of instruments. And to be honest, I've seen in different declarations it may be useful to change the treaties and to reinforce, but to do what? maybe to change the majority rules in the Article 7, maybe, but for the rest, now it's possible for the Commission to go to the court, and we have a success before the court. Of course, we need to follow the rules, because if we ask to have a full respect for the rule of law, we try by ourselves to do the same. And there are different procedures that take some time, and I said we are going to the end also to a request for a fine when it's necessary, like for the Polish case. But if it's not enough to go to the court or to publish the report that we have as a new tool since 2020, the other solution is to go to the Council, not for the Article 7, but for the conditionality mechanism, or due to the Next Generation EU, to put in the different national recovery plans some requests for reforms and to verify that the reforms are put into place. But there, we need the support of the member states. And to complete our tool, what is very important is to organize more and more debates at the national level on the rule of law in the country and in Europe, and in the more difficult case that we have. Why? We have a very large support from the European Parliament in all the discussions about the rule of law. The Commission tried to do the job. There are some criticisms, but I have said what we try to do about the rule of law. Before the Court of Justice, or with the rulings of the European Court of Human Rights, we have a real support too, to go in the same direction. And we need more and more to take the Council on board. It's more difficult, of course, for the member states to discuss among them of the rule of law. I said, on the report is the case now. It's new, but we have now, since the German presidency, a real discussion on the rule of law in different formation. The next step will be to have a real pressure from the different member states on the member states where it's possible to see a real breach of the rule of law. That's the conditionality mechanism order. But to conclude, if we want to have the Council on board, the only one way is to have a real debate at the national level, in the Parliament, and in the society, with the public opinion. Because if you have ministers, I was minister during 20 years, going to the Council, it's very nice to have a report from the Commission. It's nice to have a very strong resolution from the European Parliament. But the only one really efficient pressure is the pressure coming from their own parliaments and their own public opinion. And that's the necessity that we have now to try to install a culture of the rule of law and to see that also in the Council it's become to be normal not only to discuss, but to take actions if it's needed. It's a long process, but I'm sure that we have all the tools now at our disposal. It's a question of a willingness for all. It's sometimes difficult for the commissions, maybe for the court, for the European Parliament, but now it's time to see real evolution also in the Council in the same direction, not only to discuss, to analyze the situation, but if it's a necessity, to take an action.
Thank you so much. There were some hands from this side also. I try to be a bit, to have justice in both sides. Yes, in the middle here.
Thank you so much, Commissioner, for your very broad insight as well as being so detailed. I'm also a PhD student in EU law at Humboldt, and my question relates to values, or more specifically to Article 2 TEU. It's slightly more technical, if you forgive me. But I was sort of wondering during your speech, we've seen sort of Article 2 in a combined reading with Article 19 being operationalized to solve the independence cases and the Portuguese judges cases. And now we're just maybe starting to see a new development relating to Article 2, which may be leading, or that's my question, will it be leading to possibly using Article 2 as a self-standing principle to actually set minimum standards or even substantial standards on other values such as democracy, possibly fundamental rights, rule of law, and so on, as maybe we have seen in a more recent infringement proceedings against, I'm not entirely sure, either Poland or Hungary on media law, LGBTQI, sort of very restrictive media laws, which have been sort of systemic or risen to a systemic level. So will we see a development of Article 2 in that direction in the future? Thank you.
No, it's true that when we have started to discuss about the rule of law report, my first request was to have a report on the independence, quality and efficiency of the justice system, because I've said sometimes it's fine to have an independent judge, but if it's qualified and efficient, it's also good. So we are working on all with the Justice Scoreboard and then the report. And we have had, due to many discussions also in the Commission, chapters on corruption, media, and checks and balances in general. But we have tried to limit the scope because it's a huge work, I will say, for many services in the Commission. I have said how many contributions we receive, how many contacts we have in the Member States and with stakeholders for the rule of law report. And I'm sure that now we have a good methodology and a good scope, and we don't need to extend that to all other discussions. But that doesn't mean that we don't have other instruments. You mentioned yourself. When there is a problem of fundamental rights in one of another member states, we have the possibility to act on the basis of the Charter of Fundamental Rights, of course, if there is a link with the EU law. Because it's the Charter itself that, of course, a discrimination is one thing, but it must be, to give a competence to the Commission, in relation with EU law. And you mentioned yourself, Club Radio and the discussion about the media in Hungary, but also the so-called law to protect the children, where we are considering that there is discrimination against LGBTI community or on the basis of sexual orientation. For the moment, we are before the court. And as I said in my introduction, it's normal to have different views. But if at the end the court is following our reaction, it will be a binding decision. It will be possible to stop the process in Hungary about that. Like I said about the twinnings between some municipalities in Europe and in Poland, but if those municipalities in Poland decide to be LGBTI-free, we have pushed pressure on the funding, and it was possible to see some positive evolutions in different municipalities. So we have other instruments, and we'll continue to do that, and we are publishing a report every year about the Charter on one element. Last year it was the digital world and the fundamental rights. This year it will be the civil society. And so in December, I said we'll have a report on this. But we will continue to go to the court, if it's needed, about fundamental rights. But again, we need to have a link with EU law. To give you an example, I've seen many reactions after the decision of the Constitutional Court in Poland concerning abortion. Of course, we have given a political reaction. It's a backsliding for not only the woman, for the fundamental rights in Europe to see that. But we don't have any competence about that. And to explain, you have seen the decision of the Supreme Court in the US. So there were many reactions in Europe. But in one of our member states, abortion is a crime, in Malta. So it's quite difficult to say that we don't have also our own problems, but we are not competent to act, except if I'm looking to Poland, if, again, we are acting against the non-independent composition and functioning of the Constitutional Tribunal in Poland. And we are going back to, and why it's so important to work on the justice system, but because it's the first protection of the fundamental rights. If you don't have an access to an independent judge, you don't have the protection. And so we are working on it, but we try also to introduce, it's true, infringement proceedings and to use the tools at our disposal. You have seen maybe in the last days, to conclude, discussions about the enabling conditions for some funding to Poland due to a non-compliance with the Charter of Fundamental Rights. So we will maybe combine some possible actions before the court, but also some actions on the funding, if it's possible. So we use the same kind of instrument, but not the report of the rule of law, because it's impossible to put in the report so many chapters that we will try to act on all the different fundamental rights enshrined in the Charter. So we try to use other tools. And on democracy, you will see a defense democracy package that we will propose before the European elections. And it was announced in the State of the Union speech of the President of the Commission this year, because there also we have seen that there are many problems about the influence of foreign actors on elections and many other kind of this situation that we need to take into account, like disinformation.
Thank you so much. I was allowed one further question, so it's a bit... Oh yes, if this is possible. Okay, then we take you three, just for the ease. You start, and then you and the colleague here. Okay.
Mr. Commissioner, Thank you very much for being here. Thank you very much for your interesting speech. My name is Svetlana Neubaum. I studied German and European law here at Humboldt University. I would like to ask you about Ukraine. It's a very difficult situation, and at the beginning of your speech you mentioned the situation. There are two questions. First of all, I would like to ask if there are some possibilities to help Ukraine to be a member state of European Union as soon as possible. Are there any ways to do it and not to wait for a long time to follow all criteria? The second question is about war crimes. Just trying to understand legal standpoint. Who is allowed at this situation to hold these investigations of war crimes? And what kind of a court could take a last judgment stating that? Thank you.
Thank you. We continue with your colleague. Yes. Yes, thank you very much. I would like to ask you about young people specifically. So you mentioned going to Budapest and other European capitals. And do you have the feeling that the political divides that we see all over Europe continue also with young people from academia, young professionals that you talk to, or do you see sort of different approach to the rule of law? Is there sort of a more common ground on the understanding? And yeah, what is your impression on that, and how do you incorporate that into your work? Thank you.
Thank you very much. And then there's, I'm sorry I'm so arbitrary, but you should have asked the first question. There was a lot of time. Please.
Yeah, my question actually also related to the previous question about war crimes, Russian war crimes in Ukraine. I was just wondering whether you could elaborate kind of on the EU's work in investigating the war crimes committed by Russian perpetrators in Ukraine, and also kind of its relationship to the ICC and how kind of you're collaborating there, and how you maybe assess the prospects of this investigation being successful and potentially perpetrators being convicted. Thank you.
So maybe first about Ukraine. The accession process, you have seen that it was possible to give the status of candidate to Ukraine and Moldova. And so we start the process, and with my services we are in the process, certainly for our part, and again, the reforms in the justice system, but there are many other reforms needed. And you said, is it possible to go as fast as possible on both sides? If it's possible to see real reforms in Ukraine to fulfill all the requirements that we have put in the discussions that we have had about the situation now, of course we'll see some progress. But we need to be attentive, and we have said in our enlargement strategy that we will start with the rule of law and we will conclude with the rule of law. So it will be important also for Ukraine to make new steps in such a direction. There are real progress. To give you an example, the fight against corruption, it's a huge problem in Ukraine since many years, and due to the involvement also of international experts and experts from Ukraine, it was possible to rearrange the National Anti-Corruption Bureau and other kind of bodies in charge of this, and there are some results. I discussed with some authorities because I was in Kiev some weeks ago, and unfortunately the day of the new strikes of the Russian army on Kiev, so we had some problems during the day, but we have seen that there are for the moment condemnations of many judges for corruption, and there are some judges in jail for the moment in Ukraine. So that's become to be different, but there are a lot of things to do. So it's a long journey. It will be not in one day, but that depends from the reforms that will be possible to organize. And we will follow the accession process very closely, like we are doing with all the candidates countries. And you see that in the Western Balkans, if there are progress, we are saying that, but if they are backsliding, we are also saying that, and we take that into account. So now it's a real dialogue and real discussion on both sides. We need to be very attentive. About the war crimes, I start from the 11th of March to discuss with Eurojust and the Genocide Network, European member states, but also third countries, about the situation in Ukraine. And what we try to do now, different elements. First, we want to use all the existing tools. And so we try to provide support to the Prosecutor General of Ukraine. I visited Borodinka near from Kiev with the Prosecutor General some weeks ago to see the place where there were some war crimes evident. But we need to give support to collect evidence and to protect evidence. So to collect, we have sent some experts. Germany will send again 8 forensic experts, I'm sure, in the near future, after other member states. So we try to send experts, equipment, security equipment, of course, but also communication equipment to Ukraine. So to help them to collect evidence and to organize investigations on the ground. Because it's first the Prosecutor Office of Ukraine who is doing that. And we are doing that also with a change in the regulation of Eurojust, the agency in charge of the cooperation between the prosecutors in Europe and the judicial system. I've proposed to the Commission to change the regulation, and it's done, to be able to store the evidence collected in Ukraine and then to exchange evidence with all the prosecutors that are needed to receive those evidence. I mean, video, photo on smartphone, satellite picture, and so on, because it was needed to adapt the legislation and to build a new data bank in Eurojust to be sure that we have a secure place to store and to exchange evidence. Which I said the Prosecutor General of Ukraine, but also there are 14 member states that have started investigations about war crimes in Ukraine, including Germany, due to or the universal jurisdiction, or the involvement of some nationals. To be concrete, if there's a murder of a national journalist, of course, immediately there's a national investigation. So there are different reasons. Then we have the investigations from the International Criminal Court in The Hague. The prosecutor Karim Khan is on the ground with investigators to do that. And so we have already seen many cases in Ukraine. They have collected information about not so far than 40,000 incidents now, and they try to organize investigation about more than 3,200 possible war crimes, and there are 170 suspects and already 10 condemnations. So you see the gradation, but we will continue to do that. And in the ICC, it's maybe possible to start trials at the end of the year following the prosecutor, or maybe beginning of next year, we'll see, but they are so far. That's the framework, and I will add that we are working also with the European Court of Human Rights, because there is an interstate conflict between Ukraine and Russia there, and they are waiting for thousands of individual cases for violations of human rights. To give an example, property. There are many confiscations or destruction of houses or properties in Ukraine. So there are many possibilities to use the existing tools. The second element in the process is that we ask to Ukraine to take part in the International Criminal Court, so to ratify the Rome Statute. It's very important to show the participation of Ukraine in the international organizations able to proceed with a real success to have accountability responsible for perpetrators of war crimes. We have the support of the political authorities in Ukraine. I know that we need to explain more in detail to the military people. I fully understand that it's not a real risk if you defend yourself. They are not committed a war crime. But in a war, to be concrete, in Ukraine too, I'm sure that a very large majority, quite all the war crimes are committed by Russian soldiers against Ukrainian civilians. But in a war, it's possible that you have also war crimes on the other side. And it was said at the beginning also by the President Zelensky that he will take the measures if it's the case. And to give you an example, we are sending, I was Minister of Foreign Affairs during some years, peacekeeping mission from the UN in many countries, and first of all in Africa. But if some members of the peacekeeping missions are committed war crimes, aggressions, violence against women or children, to give an example, we need to organize investigation and prosecutions. It's due to some individuals, but we need to do that. So it's important to ask to ratify the Rome Statute, and then we are in discussion with Ukraine about the request of Ukraine to create a new tribunal or a new solution for the crime of aggression. And we have said, again, we will use all the existing tools. We are not against, but it's very important to my mind to be backed by the international community. So maybe to think about something with the UN, not the Security Council, because it's impossible to have the support of the entire Security Council, of course, but this General Assembly or the Secretary General, because there it was possible in the past to work in such a way with the situation in Cambodia or in Sierra Leone. So that to say that there are many things that is possible to do, and I went again last time to Ukraine to discuss with the Prosecutor General about that. Normally, the intention was to see some members of the government on the Monday, but on the Monday we had some strikes on the city, so it was impossible to organize that, and I took the road back to Warsaw, and we were doing 13 hours on the road to come to Warsaw. Then on the discussion and the possible participation of the young generation in those discussions about the rule of law and the process, is what I've said about the culture of the rule of law. We need to install more and more culture of the rule of law. Of course, it's possible to do that with many discussions that we have, I said, with civil society organizations and with the parliaments in the national capitals. But it's very important to have a sort of relay taken by different actors. I mean, now we have a cycle on the rule of law. So it will be every year in July that we'll publish the rule of law report with recommendations and an assessment about what is possible to do to implement or not the recommendations. So why not to have with universities, with bar associations, with many civil society organizations, but also with many young organizations, debates at the national level about the rule of law on very concrete elements. And I said in my remarks, the difficulty is to explain what is at stake in the daily life of citizens. Because rule of law, it seems to be far from the daily life. But there are very concrete examples. Said if you have a problem, is it possible to go to a judge? Just that, and to have an impartial judge in front of you. And that will be maybe the next step. The reason why I've started, it was with the French presidency, to introduce a sort of debate on the rule of law in the council with the Minister of Education. Because I'm sure that maybe also in the different process that we have in the education system in all the member states, it must be important to introduce a reference to the rule of law and the values. I'm sure that in the young generation now, we have a real attention to the climate. It's very clear when we have seen so many demonstrations and actions coming from the young generation. But I'm sure also that the protection of values, it's something very important too for the young generation. So I'll try with the Fundamental Rights Agency in Vienna, to give an example, to see how it's possible to organize more and more debates and participation in schools, in universities, but also in with young people, in an association of young people. And like I said, of course, sometimes I'm invited to speak before the Friends of Europe in different capitals. It's quite easy because they are convinced. But to go and to speak to all the young people also out of the universities, in some industries, in some factories, in the streets, it's more complicated. And there we need maybe the support. And I know that to conclude, if there is an emotional issue, it's easier. When we are speaking, to be honest, about the disciplinary regime of the judges in Poland, we have seen some demonstration of lawyers and judges. When we speak about a possible discrimination due to sexual orientation in the law in Hungary, you have a huge reaction in the population. And so it's important to explain what are the possible discussions on the rule of law and fundamental rights and democracy. And I'm quite convinced that slowly we'll have more and more participation also for the young generation about that, like we have seen a real participation, it's true, in the debate about climate change.
You can leave the technical subjects like disciplinary issues for judges to lectures in universities where even there are exams written on these issues. So in the end, I always have the pleasant task to thank everyone, in particular today, our audience. Just to remind you that Walter Hallstein in the 20s was a student at this university, so that he gave his name to the Institute. I'm very grateful to Madam President to be with us all the time, to my team to be within the university to support this, to our cooperating partners, Stiftung Mercator and Stiftung Zukunft Berlin. That is very nice that the support is essential for us, but also for joining us. But above all, of course, to our speaker, Commissioner Reynders, and to give you a little souvenir, this is a collection of many Humboldt speeches before you, so the second volume, so to say, and I just want to say thank you very much for being with us and for discussing with us. Thank you very much.
I will read the next volume. Thank you very much.